Good afternoon. My name is Hae-Sun Kim, advisor for Gangnam Labor Law Firm. Today with Labor Attorney Jeong Bong-soo, we will discuss about the Labor Standard Act, Article 24, which stipulate that about the dismissal for managerial reasons. So could you define the meaning of this terminology, please?
Yeah. Hello. How are you today? This is Bong-soo Jeong, Korean labor attorney. So Article 24 of the Labor Standard Act stipulate about the dismissal for managerial reason. So that means due to the business deficit or some slow down economy, company cannot compete in the market. Then they need to reduce labor cost. So biggest cost is labor cost. So they want to reduce the number of workers. In that case, they are using this article. So this article is like when employer follow the requirement for managerial dismissal, then it is regarded as a justifiable reason for termination. So what are requirements for? There are 4 requirements to satisfy justifiable reason. So first one is there should be urgent necessity in relation to the business. So business suffer from the long time deficit or business negative environment. In that case, it can be a reason. Even though there is a justifiable reason, employees still must follow other requirements. That is, they must make effort to avoid dismissal. Then how they avoid dismissal is they need to promote the early retirement program. This means a voluntary resignation process. So employee, they cannot accept the resignation. So, but if they have some payback or special compensation for early retirement, then they are willing to accept that the agreed resignation. So we call it the voluntary resignation system. Yeah. Also, third requirement is the company should find. Also, they must make a rule for justifiable process for choosing and those who will be dismissed. That means they need to make so acceptable the criteria for choosing the target workers. So in this process, they must consider workers' situation. Yeah, then it can be accepted as justifiable, like a balanced the criteria for choosing right target workers for termination. Also, last process is employee should inform 50 days in advance to employee representative or labor union that represent the majority of workers. Then they negotiate with those requirements like effort to avoid dismissal or some fair criteria for choosing the target workers. Then if employees satisfy those 4 requirements, those managerial dismissal is regarded as a justifiable reason for termination. Yeah.
I see. This article explains the detail about the restriction on dismissal for managerial reasons. And based on this article, I understand the Gangnam Labor Law Firm has published a book which is entitled The Workforce Restructuring Manual. So could you briefly explain and introduce about the content of this book?
Yeah, this book I published, this second edition. What I try to do with this book is I want to provide a scenario, also the process, how the employer can take right process to satisfy this managerial dismissal. So I showed some examples how I can take a right appropriate process for dismissing those workers due to the managerial reason. So, but this one is the first chapter I tried to show that this managerial dismissal should be last resources before they terminate their many workers. They need to consider some other way to avoid the dismissal, like providing some settlement agreement or voluntary resignation package process, so then they can avoid the first termination. Yeah. Also, maybe you can find some related model or scenario how to the dismiss people, your workers due to the managerial reason properly by following the Korean labor law. Yeah.
I see. So compared to other like U.S. country or other some European countries, dismissal is sometimes easier than Korea. So can you give us some example of some model case of a dismissal case in the foreign country?
Foreign country, like employee working in the USA or Britain or Canada, Australia, they are subject to easy target for the termination by the employer. But in Korea, we have very strict law to protecting their workers. So in the world there are two different legal systems. One is the common law system and compulsory legal system in Korea. So we are following the compulsory legal system. So it is very difficult to fire people in Korea. But USA or some the Commonwealth country in the world, they it's easy to fire the workers because they don't have a compulsory labor law, but their cases is usually judged by the judges in the court. So in their countries it's very easy to fire people collectively or individually, but in Korea it's very difficult to fire people. Yeah.
I see. Thank you very much for your explanation and some example of this case. Thank you.
Okay, thank you for watching. Bye bye.